possible to prevent serious mining impacts, then we need better rules than these to ensure it. Is mining really our best solution to promote jobs and economic growth? The rule before you reflects a surprising lack of responsiveness to strenuously voiced, well-reasoned public concerns about mining during the 125th, the 126th, and now the 127th legislature, that these rules are insufficiently protective. Groundwater contamination is allowed as a given in the enabling legislation, which is no longer legal, and in the rule that you have before you. Consider this: in their response to previous public comments on these rules, Maine DEP stated, quote, unregulated discharges to groundwater that within a mining area result in failure to meet water quality criteria otherwise required by state law are specifically allowed by statute for metallic mineral mines. Maine DEP also admitted that, quote, such groundwater will almost inevitably leave the area where the discharge occurs. By Maine DEP's own admission, even with extreme vigilance, metallic mineral mining will contaminate ground and surface waters of Maine. That's why these mining rules make such astonishing allowances for decades to generations of waste treatment before water quality standards must be met. Compared to other locations, we have an astounding quality of place here in Maine. Our waters are clean and ecologically healthy. Our landscapes are inspiring. In the long run, the unforeseen consequences of hasty and poorly considered law are far more costly and detrimental to the state's economy, environment, and reputation than taking the time to do it right. I urge you to return to Maine's long-standing legacy of careful and deliberate stewardship of our unique and irreplaceable natural resources. I urge you to vote for LD 750.
Questions? Thank you.
Catherine Sarah?
Well, Representative Welsh, Senator Saviello, and members of the ENR, thank you for being here to try to be taking care of Maine and our important resources and our health. I appreciate that you're here. Appreciate being able to talk to you. I'm here to ask you to do what you've been charged to do, to protect the natural resources of our state. After observing during these last couple of years the testimony by our fellow Mainers and seeing the stacks of data given to you on failed mines by some of the most knowledgeable experts in the field, and after those rules were rejected last year, I ask, why are you now rushing to fine-tune these same inadequate industry-written rules? Corporations are not charged with protecting us. You are. In this case, that baby should be thrown out with the bathwater. And just what is this emergency that you claim gives you the right to violate Maine's Administrative Procedures Act by trying to push through this law and deny us, along with the experts in this field, ones who are not paid by industry, to say what industry wants you to hear, our right to review and comment? There will be an emergency if these lax rules are implemented, and we the people are left with the impossible, costly task of cleaning up what will be your legacy. If you do the wrong thing, you will be held accountable, and we will not forget. You have an excellent opportunity now to support LD 750, which will allow the careful, thoughtful input from your constituents and the impartial, highly respected input of third-party experts. Please do not let us down. Please do not let our children and their children down. We have one of the most beautiful, pristine states in the United States, which will give many of us Mainers a chance to live healthy, productive lives, where we can make a good living and contribute to the welfare of our state, rather than be strangled by the cost of cleaning up yet another failed mine and the surrounding polluted watersheds. Please do the right thing. Support LD 750. We will not forget.
Questions? Representative Campbell.
Yes, I'm intrigued by your testimony. Could you describe how the industry wrote the rules?
I believe it was industry J.D. Irving, who had hired experts who gave information to the DEP, and the DEP relied on a lot of that information in writing these rules.
Questions, any others? Thank you. Charles, it's Jeffrey.
Thank you for this opportunity, members of the committee. I just want you to know I'm not related to that other Fitzgerald.
He's not claiming you either.
Oh, yes, yes.
Thank you, Mr. Smith, good teacher.
I can't arm wrestle, but I'll take them on at a game of ping pong. As citizens, we're kind of frustrated. You know, we're here today for the same reason we've always been here, which is to, what we see, regardless of whether we're right or not, as an industry-driven, irresponsible approach to metallic mining in Maine. You know, it'll bring big financial returns to the corporations, but we believe that it will leave Mainers with the long-term cost of cleaning up the likely long-term pollution of Maine's pristine water for thousands of years to come. You know, we see the damage as being inevitable, permanent, and that it'll destroy the livelihood of many of those who depend on these clean running waters for their income. We're also here, most importantly, to support LD 750, which says simply, let's be careful and do it right. It's what we asked you to do last year when the rules were rejected by the legislature. We told you then, almost unanimously, that you can't tweak rules designed to make it easy for mining interests, that you should start again in a well-defined process that includes third-party consultation with independent experts. You refuse to do so by coming back with the same weak rules, once again presuming that you can tweak them into acceptability. Well, it won't work. You can't politicize mining rules by compromising when the conditions of mining the high sulfide deposits in Maine are in the highest risk category. You've been provided with megatons of detailed material at these hearings. I know, I carry them around, pointing out the high likelihood of failure if you proceed down the path you've chosen. LD 750 provides a framework, a pathway, an outstanding opportunity to arrive at rules where there can be public confidence that in allowing the removal of these metallic riches, the environment is well protected from contaminations, and that the waters of northern Maine woods will remain free of the poisonous effects of acid rock drainage. You should be warned if you proceed down the path you are taking, which we believe is in violation of the Maine Administrative Procedure Act, and choose to waive that law in the legislature, you will be violating the public trust and the purposes of the MAPA. You will not be forgiven for that, and you will be recognized properly so, as the handmaidens of industry in a special interest-driven process which will endanger the greatest repository of clean waters in the eastern U.S. Supporting LD 750 is a way out of this mess, which with public and scientifically arrived at input will lead to responsible rules whereby there are no social costs during mining or after mine closure. The real question is here, what's the hurry? The riches contained in the mine deposits will not deteriorate with time, and there may be emerging technologies which can remove them safely and restore a closed mining site to a safely uncontaminating state. It should be obvious that there is no alternative. Go with the people and start again with LD 750.
Questions for Mr. Fitzgerald? Yes, Representative Campbell.
Thank you. I wasn't here 2 legislatures ago, 3 now again, when this law was passed. And the legislature sits for 2 years. So assuming it was the end of one, we're at least 3 or almost 4 years of testimony and public input. Do you, were you not here then?
I've been here from the beginning. I've testified at every one of these hearings. And what I've seen is a process that is simply not responding to all the work that people through this state, both expert and non-expert, have done in attempting to provide you with the information you need. Studies by experts, the work commissioned by Lindsay Bowker to assess the dangers of mining Bald Mountain, the David Chambers study, the work that we're bringing forward to you, that she is bringing forward to with regard to Dr. Robert Moran, one of the foremost experts in the hydrology of mining. All that has been put before you. I've put all this stuff into the evidence before you. It's as if you didn't read it. That's why we are frustrated as people, because we've seen this process go on, and we've seen you repeatedly ignore what we told you. You can't tweak these lousy rules. We said that loud and clearly in the last legislature, but here you are trying to do exactly that. So frankly, you are ignoring the huge, almost unanimous response against this by ignoring the process that we've asked of you. You're not doing it.
So were you involved with the VEP process and the rulemaking process?
I came to every hearing where I could possibly testify. And I've put in my testimony each time.
Thank you. Other questions? Thank you.
Harry Ackerman.
Harry Ackerman.
I'm Harry Ackerman from Harmony. Good morning, welcome everybody. I want to try not to repeat what has been said already. As you know, since I testified last time also, I have some mining background. I want to talk about the California gold rush in order to make a point that concerns taxpayer cost. When I went to California, I traveled along the American River, and although at this point I had my mining experience, I was shocked by the strange phenomena that I did not expect whatsoever. Of course, the techniques, the mining techniques, are completely different and are not comparable in that sense. There was these huge boulder fields along the river that made it totally impossible to approach the river. And it never occurred to me that boulders, just boulders, could be so strange. And if you think of it now, this is 150 years after the gold rush, there was a short time period, a few years, where there was a lot of money being made, and then there was 150 years where no tourists could approach this river, and a lot of business were just simply put out of commission. This was a big surprise, at least to me, but I'm also sure it was a big surprise to the people that were in charge and lived in that time period. And that is one point I want to make, that when it comes to mining, there's going to be a surprise, a big surprise waiting for us that we cannot foresee. Now, if we hear the testimony of the proponents of mining, there's new technology, it is all very well researched, and everything is going to go just perfect, and nothing is going to go wrong, and there's hundreds of jobs being created. And I'm not saying this to criticize these proponents. This is a normal thing that we humans do. We are excited about something and we see this super rosy picture. Maybe these job creations, instead of hundreds, are only 100 or 200 jobs instead. And what is that compared to Maine? Nothing. This is just a small business somewhere. The surprise that I was pointing out can negate a lot of businesses that otherwise would prosper over decades or 100 years or more. And that is the loss for the tax that the taxpayer has to cover, because these things cannot be covered by the mining corporation. They will have to be covered by the taxpayer in terms of less revenue, less jobs, and this is something that I think we forget. Mining is very dangerous. It is not like forestry or agriculture, let's say.
Mr. Ackerman, you need to finish up.
I'm finishing up. That we can regulate as we go. Mining is so dangerous that we have to step back and take extra time, and I urge you for that reason to vote in favor of this bill.
Thank you.
Thank you.
Any questions? Oh, thank you.
Kingsbury.
Oop.
Give him a minute to hand it
Yeah,
out.
I won't start you until everybody's got it. We have Catherine, Caitlin next. And then, is there anybody else from the public? Well, she's from the, she's representing AMC, so the public should go, so we have three people, anybody else? Those three, you three people, just come up one at a time before Caitlin goes. Okay, you ready? Oh, $5. Are we ready? All right. Go ahead.
Thank you. Thank you, Senator Saviello, Representative Welch, and esteemed members of the Environment and Natural Resources Committee. My name is Lou Kingsbury, and I reside in Pittston. I usually just read down through what I hand you out, but I've heard a lot of this before, so I'm just going to cut to the chase here. On November 2nd, 1993, there was a referendum ballot question, number 5, that was passed by 73%. And what that ballot question implemented was a change to the state's constitution that said that state park land, public lots, and other real estate held by the state for conservation or recreation purposes and designated by legislation implementing this section may not be reduced or its use substantially altered, except by a 2/3 vote of all the members elected to each house. Since then, all public lands held for conservation and public recreation have been so designated under 12 MRSA 598A. Now, the reason I bring that up is that seems to be a key thing in dealing with the public lands that may or may not be mined on. Now, we're currently grappling, I guess, with that in the Forestry Committee in terms of either commercial timber harvest versus sustainable harvesting. We're going to, if the rules go through and we start mining, also going to grapple with that in public lands. Now, we had a discussion, Senator Saviello and Representative Duchesne, at my previous testimony concerning whether or not we already have the right to mine on public lands. I submit that we don't yet, that if you want to mine on public lands after rules are passed, that you have to bring it back to the legislature and get a 2/3 vote before a particular piece of land can be mined on. I brought that to an attorney that is also a senator in our party, and he agreed with me. So that's really the end of my discussion. You've heard everything else here several times, but I think that public lands are a major piece of the emotional discussion that will go on with mining, and that there are some places that I would submit that they already have their eyes on. Now, one other thing, the setback requirement. We had a setback from public lands. It's been in the rules as a 1/4 mile. Some of us have submitted that it should be a mile. This 2/3 vote could take care of that issue. If the law was a mile and somebody wanted it to be less than a mile, they could get, under a 2/3 vote, a relaxation of that requirement through this constitutional amendment that was passed.
Questions, Mr. Kingsbury? Representative Tucker.
Mr. Kingsbury, could you tell me why you mentioned specifically Bigelow Mountain in more detail?
Well, thank you, Representative Tucker. Bigelow Mountain has always been seen as a prized potential mining site because it has a volcanic upwelling that runs right up through the center of it. Now, the massive sulfide deposits are found in the volcanic upwellings, and in this mountain there is a face that goes down Bigelow, and it's easily prospectable and has been over the years. And what they're doing is in that face they are finding the metals that we're looking for. They don't know what the concentrations are. You'd have to do core sampling to find that. But Bigelow Mountain has also been very heavily cut recently, and permanent roads have been installed. I believe when you bring in gravel, you create a permanent road. I would hate to see Bigelow become a mining site. So that's why I use that as as an example of what could happen on our public lands.
Mr. Marvin shown that as a site? I don't remember that.
No, it has not had core samplings drilled. What it has had is prospecting. Your law that you referenced, 12 MSRA 549B, is actually a prospecting law more than a mining law. And prospectors go out and can do that from a surface examination. And that's what's happened on Bigelow, surface
So do
examination.
you have any evidence of somebody deciding they want to come back and be crazy and they ask to mine at Bigelow?
Well, if people think that they've already got the right to mine all public lands, especially those that have been excluded from the rules as they're presented now. I mean, lands for Maine's future have been excluded from the rules as mineable, the way I read it. So that was one of the things that I was bringing up. So I think the rules ought to be changed to go back to all lands listed under 598A, designated lands, should start out as mining exempt, and then on a case-by-case basis, you go back and say, okay, I want to mine this piece, and I'm going to,
I disagree.
okay.
Any questions? That's easy fix. Any questions? I disagree with mine, but I don't disagree with that. Any questions? Any other questions? Thank you.
And thank you for saying that. Cameras are on, I think, yeah.
No, I got it. There's three right in a row. Bump, bump, bump. You're up.
I'm one of them, I think.
You are.
You are.
Then you, and then you.
Let me say that I have a great deal of respect for all of you legislators, what you do. My father was a legislator, my brother was a legislator, and I was a legislative staff member. So
Welcome.
we'll establish that right away. I don't think I really need to read my letter today either, but I have become concerned with a picky little issue. And that's probably because I'm a retired law and legislative reference librarian. It bothers me that the text of the LD, Representative Chapman's LD, is not underlined except for the first paragraph. And because I know that generally speaking, the language in an LD that is going to become statutory is underlined. Now, I understand that the explanation for that is that this is a concept draft, but looking at the issues, I just want to tell you, I don't feel personally comfortable with that. I support Representative Chapman's bill entirely and the purposes of it, and I believe it's necessary. But I would feel more comfortable if I could see those provisions that are mentioned in the statement, we used to call it the statement of fact. They call it now the, what is it? The summary, they call it now. I would like to have seen some statutory language spelled out there. Okay, so perhaps it's a concept draft, but I would like you people to think about that when you're working on this. The other thing is that even if everything else is a concept draft, I noticed that the date, January 1st, 2017, is not listed up there in that first paragraph. And I studied it quite a bit, and I can't see any reason why it couldn't be, except for the fact that you don't want to put a specific date in the statutes, probably. But I'm just, well, I've shared my concerns with you. And I've been even more concerned about it since all this business about the word "and." And how the word "and" did not appear in Efficiency Maine's $86 million appropriation, however many millions their appropriation was. That makes me more uncomfortable with concept drafting. So I would just ask that you people think about it.
Questions? I think, let me just say that this is actually not a concept draft. This is, and what we all learned in the committee when we went through this, see how I did, Professor Dan? Is that the only thing they're changing in statute is they're adding the moratorium. The rest of it is unallocated language directing the department to do something.
Well, that's the way I learned it too.
So the rest of the.
Excuse me.
I'm sorry, I was just saying, only the underlying part goes to statute. The rest of it, all, if you read it, tells somebody to do rules.
Yeah, and I looked in that little manual they give legislators, and they've actually got it updated to this session. And that's what it says in there.
So
You
this-
can look, I think I gave you the pages. Yeah, bill drafting, page 4, and the form of a bill, page 8. I'm really genuinely concerned about this, and thank you for
I think this
understanding.
is actually properly presented to us. That goes back to some of the questions that we had earlier in the committee, so, but thank you. Other questions? How did I do, Dan?
A+.
All right.
Is this going to be in the midterm?
Yes, it is. Next.
Excuse me.
Good morning, esteemed members of the committee. My name is Diane Messer. I reside in the town of Liberty, and also I will not repeat some very good points that a number of very well studied and good homework has brought to you. But I will bring up a couple of issues that were made of great concern. Our water, Maine being a pristine state, and the attraction not only for us to protect it in perpetuity for future generations, but to attract others to come to this state and protect it as well and enjoy its qualities that we have spoken at length about. Water is a very critical decision. Once we've contaminated it, in many cases, there is no undoing it. The example you have are tailing ponds all over North America that are left in perpetuity, that wildlife that are drawn to it die. That cannot be used again, it cannot be cleaned. And one prime example is another type of mining, granted, but it's the whole process I'm talking about, not the specifics of northern Alberta, the Athabasca region, and the tar sands mining. There's various types of mining going on there, but one thing that's in common is a great deal of water is used, and that water is contaminated, and there is no process now to clean it. It sits in tailing ponds. Do we want to relegate ourselves to that, to contaminate our water supplies when water is becoming a scarcity all over the nation? If anyone has been reading the headlines, you hear and understand much of the Southwest, a large section of the country, is in severe drought. California, where we get a huge percentage of our food, like it or not, we need to be doing a lot more of our own growing locally, but a great percentage through all the grocery stores in the state are selling California food, and they are in severe drought now, and within a year, many communities will be out of water. That means zero. None to be had unless you truck it in. While we have this wonderful resource, we should be doing our utmost not to protect it, not getting as close as we can to the danger point, inching closer and closer. Do we allow this much contaminant? Do we have this much setback? The precautionary principle is what should guide all of us in our deliberations. Protect it while we can. And as far as the jobs that have been mentioned at length, there are very clean jobs to be had in clean renewable energy. Instead of supporting the mining activities that will not benefit the majority of the state, maybe a very small percentage, perhaps a few hundred jobs, and for how long? Until they extract what they can, and then they're gone, we're left with the pollution, and the jobs are gone. So let's focus more of our attention and effort. I understand my time is up, but I knew what you were going to say. Bringing renewable energy to the forefront and the great jobs that can be had. That technology is booming. Solar has been getting less and less expensive. So we have many other ways to focus bringing clean energy in and satisfying our job needs as well.
Questions? Thank you. Is there anybody else from the public that wants to speak? Just, okay. Just you're representing the public, right? Yourself. Yes.
Good morning, Senator Saviello and Representative Welch. My name's David Wood. I am a retired professional engineer living in Hollowell, and I love fishing.
No, the other one. No, that's bad.
These were caught by myself within 8 miles of the mountain we can't mention in Mason County. Anyway, I don't have any written testimony. I got up early this morning, threw my testimony out, did some research, and I think the rules and regulations are forever evolving. I think I support LD 750. On March 20th, mining.com, the Mount Polly disaster in British Columbia, they've now said that miners planning to set up shop in Canada's British Columbia will now have to consider alternatives to wet tailing ponds, according to new environmental regulations prompted by this last year's failure. So they have to consider alternatives to wet tailing ponds. So those rules are there. So that's one reason why we should support LD 750. Take a look at what these rules are. Another reason is, just south of us is a famous engineering college, MIT. Mission 2016, the future of strategic natural resources, has a new paper out, and we should consult that, the people doing the rules. Environmentally sensitive green mining, on how to mine green and not pollute the environment. That's what I have to say. I think we ought to look into that.
Can you, I don't want you to make 20 copies, but can you give those to Tyler? We have a library.
Yes, I could.
That way, if anybody wants to read it from the committee, they can do so.
Okay.
That
But
would
I
be
ask,
great. Thank
you should talk to the people down at MIT.
Representative Shane.
Thank you, Senator. Hi again.
Hi, Bob.
Alternatives analysis, it's actually in the rules, and tailings impoundments is one of the things they're supposed to look at. Do you feel it's just not thorough enough in the rules?
These are alternatives to
Yeah,
tailings.
and essentially the rules say you're supposed to look at these alternatives.
Well, this is a Canadian regulation. I think they just mentioned US rules.
Yeah, what I'm talking about is the provisional rules, provisionally adopted rules, specify that they're supposed to do alternatives analysis, including tailings impoundments. And my question is, do you feel that section of the rule is just not strong enough or not specific enough? Or
I feel it's not strong enough.
what would make it stronger?
Do away with the tailings ponds. There are alternative methods that do away with tailings ponds, and that should be looked at.
Okay, thanks.
Other questions? Thank you.
Hello. Representative Welch, Senator Saviello, members of the Environment and Natural Resource Committee. My name is Chip Blade. I'm a resident of the town of Camden. I've been watching, and I'd like here to speak opposed to LD 750. I've been watching these mining regulations since back in 2012 when they first came to the front. It's been quite an involved process, and I know that there's been a lot of discussion on both sides, and we came up with the provisionally adopted regulations, Chapter 200. This wasn't done overnight. It was done over a long period of time. We had the history of the Kerr American and the Callahan mines. That was before we had any significant environmental regulations at all. We've come a long way since then. And I think we ought to let the department go ahead and go forward with these existing regulations that are adopted. They're a great bunch of people. They're there to protect our environment, and they do a pretty good job. I've had the opportunity to work with most every bureau in some form or another. Some not so good, but they've been very thorough, and they do their job well. So, is there anything I can do to answer any questions?
Questions?
Okay.
Sign the sheet up.
Sign the sheet up, yes.
We have the others we have. All right, now it's table. Anybody else from the public that has not testified here? All right, you're on. Yes, sir. Yeah, we have 3 more people to testify. So the committee, so we're waiting. Oh, it's snowing again, isn't that exciting? We're going to finish this up, then we will take a break, and then those that want to go to appropriations at 1 o'clock, we're on. I think it's important, Joan and I definitely will go, because we made a significant change in our proposal back, but all of you are invited to go with us. And I think we'll reconvene about 2:15, so we have some work sessions that we can do this afternoon. So that's the plan. We may be 2:15, may be a little flexible depending on what happens on appropriations, but we plan on work sessions on the ethanol bills, correct?
And the MTBE raising.
Yes. And Mike, did you have any luck? Mike, did you get any luck getting Mike Mullen perhaps to come over this afternoon? Okay, we won't deal with the vernal pool per se, but Mike Mullen may add some, help us in that conversation, but we're not going to do a work session on that this afternoon. Thank you for asking. Mike Mullen, who's with the DEP, does a lot with vernal pools, is going to come over to have a conversation with us too. But we are not going to do a work session on that, just for information. Welcome.
Thank you. Senator Saviello, Representative Welsh, members of the Committee on Environment and Natural Resources. My name is Caitlin Bernard. I've been up here a few times. I'm here on behalf of the Appalachian Mountain Club and our 5,200 members here in Maine. We're here today to support Representative Chapman's bill, LD 750, as the nation's oldest outdoor recreation